Thank you, Professor Levinson, Professor Fisk. At this point, we're going to turn the program over to questions. Yeah.
I'll just say that if we refer to popular views, this is not my question, I'll just say, so we can also, just watch 24 hours and see what are the perceptions of, the public about legitimacy. I mean, Jack Bauer is putting people there each and every chapter of the series. So this also shows that something like it. But my more serious comments and with regard to the comparison between the U.S. And Israel, first I think there is no danger that the Israel Knesset would legislate torture, but not for, I would say, high values of human rights, just that Israel cannot afford being the only country in the world to make such a law. Maybe the U.S. can afford, I don't think it can, but Israel cannot, and I think this is part of the maybe ingenious, I would say, way the court drafted the decision, because, I mean, supposedly the president do everything, nothing in this regard. But I think the most interesting thing to think about, from my perspective, hearing your presentation, is your point about the role of the Office of Legal Counsel. And I think that here there is more, I would say that Israel and the US are more similar than what came from your lecture. Because the exception in the decision, the fact that it is possible not to bring charges against interrogators, and this is written into the decision. Who makes these decisions? The Ministry of Justice. So even in Israel, the most important role these days, based on the decision, is the role of the Ministry of Justice. And from this perspective, maybe the American condition and the Israeli condition are not that different.
Two very quick points. Justice Scalia has said on occasion that 24 was one of his favorite programs. 24 is an entirely wicked program because I think it has shaped a great deal of the American perception. On your second point, I think you're absolutely correct that judicial opinions, laws are not self-enforcing, and one does have to ask, well, what accounts for the willingness to prosecute or not to prosecute? How genuinely independent are the prosecutors? Again, in Texas, perhaps it's true in Oklahoma, but we elect everybody in Texas, so district attorneys are elected officials, and that undoubtedly on occasion is going to have some genuine consequence. One of the things that will be in the published version of the piece is brief discussion of Justice Barak's role as Attorney General when he acted very independently. And I have been told the Attorney General in Israel is supposed to be more protected against ordinary politics than is the case in this country. I mean, one of the scandals of the Kennedy administration, frankly, was the appointment of the president's brother as Attorney General. He turned out to be a good Attorney General, but this is like defending a police search on the basis that actually they found the evidence. And so I don't know enough about contemporary Israeli politics to know whether contemporary attorneys general or prosecutors feel a sense of resolute independence or not.
May I respond? I agree, Daphne, with your point and Sandy's response to it, but I do want to underscore one crucial difference between the United States in this decade that I've been talking about and Israel. I don't know about today, but Israel through the eyes of our own Barak. There are two ways to deal with torture. One way is a criminal prosecution, as you suggested, which is in the control of political offices. And the second way is the victims of torture could begin actions, not in the United States of criminal prosecutions, but civil suits. And in fact, in the course of this decade, such suits have been brought by people who were the subject of extraordinary rendition. These are people, as I pointed out in my talk, were imprisoned by the United States and then sent, for example, to Syria. I'll just talk about that case. And were tortured by the Syrian officials, trying to get information that was useful to the United States. And of course, as I pointed out when I visited Tulsa a couple of years ago, before Obama had taken a position on this, that kind of subcontracting is as unlawful as if the United States official did it directly. And the victim of this rendition subsequently brought suit in the United States seeking damages and declaratory relief. And so we didn't have this political control. We had an individual initiative of the litigation. And to the embarrassment of the American judicial system, they dismissed the suit, eventually with Obama's blessing. They dismissed the suit on the grounds that such a judicial inquiry would intrude into the domain reserved for the executive or the legislature on issues of military or foreign policy. If there's one lesson that can be drawn from Justice Barak's life's work is the inappropriateness of such a kind of deferral. As he would understand it, we have to defer to the military on military questions. But when it comes to the basic normative values, the clash of normative values, that's not a military question. That is a question for the courts. And I don't know if that still controls in Israel today. But I think that is a fundamental difference between our two systems, maybe attributed to Justice Barak's contribution. But I think our system has a kind of double injection of political values at who could initiate the criminal prosecution, and if there's a civil proceeding, allowing the executives, political calculation of the clash between values of freedom and security to be controlling on the judiciary. And that's a fundamental difference, and I think in the American system and the Israeli system.
Bryce has a question back there, and I think this is probably going to be our last one so we can stay on track.
This is for both Professor Fiss and Professor Levinson. One of my fondest memories of my legal education was studying the Guantanamo cases in Professor Inzeroth class my first year. And I can't remember if it was Hamdan or the Boumediene case where Sandra Day O'Connor made a really profound statement in her dissent that highlighted the gap between law and life, as was discussed in our first book. She said, "It is during our most challenging and uncertain moments that our nation's commitment to due process is most severely tested. And it is in those times that we must preserve our commitment at home to the principles for which we fight abroad." Bearing that in mind, what policy framework do you envision which reconciles both the American constitutional principles and the need to respond to legitimate terrorist threats with regard to detainee treatment and interrogation?
Do you want to go first?
Mr. Hawk, don't take those words on face value and without the continuation. Now, I think the decision that you're referring to is Justice O'Connor's decision in the Hamdi case. That is a case in which she talked about, I think if I recall correctly, the issue in that case was whether an American citizen who was captured in Afghanistan and imprisoned as an unlawful enemy combatant could have an evidentiary hearing on his claim that he did not fight for the Taliban, but was in Afghanistan and for personal reasons, and was seized by bounty hunters in Afghanistan and handed over to United States troops. And Justice O'Connor, to her credit, did say that as a matter of due process, this is like the only decision for the decade, as a matter of due process, he was entitled to an evidentiary hearing. Great, we all stand and applaud for that. But when it came to the details that Sandy spoke about, it was, I think, a betrayal of the elementary principles of due process. Not only because the way she sort of defined the burden of proof, not only because of what she regarded as to be admissible evidence to sustain the government's position, but she even said, and here she only spoke for 4 of the justices, she even said that an evidentiary hearing to determine whether this person was an enemy combatant or simply in Afghanistan for personal reasons could be held by a military tribunal. I mean, what kind of conception of due process is that? So, I mean, I applaud that kind of rhetoric, but I think as lawyers we have to be much more careful and pursue the inquiry all the way down to the details of what she was doing. And this, I say, is the high point, one of the high points of the last decade. So I think we have to read these American decisions a lot more carefully than they've generally been. There's been a lot of, there were really 3 waves of decisions in June 2004, in June 2006, and June 2008. In each instance, and I'm grateful for that. In each instance, the administration was rebuffed, and that rebuffing made headlines, banner headlines. But when you looked at what was decided, it was an extremely limited, crabbed decision of the Supreme Court. And in this entire decade, I would say there has never been a decision by the Supreme Court, or even by the lower courts, that when the courts viewed themselves, as Barak had throughout his career, as the guardians of the Constitution, and they have never spoken forcefully and eloquently as to the importance of protecting the fundamental values of the nation, even when they knew they were being confronted by evasive strategies by the administration. That's the judicial tragedy of the last decade.
Yeah, I agree with really everything that Owen has said, including the need to be skeptical of self-serving paragraphs by judges. So what occurred to me as Owen was speaking was Plessy versus Ferguson, where the majority opinion says, were we to believe that Louisiana's policy was designed to oppress or annoy, then we would certainly intervene, because the 14th Amendment says you can't do that. But of course, as everybody knows, what the Supreme Court in its 8-1 majesty decided is that segregation on the New Orleans railroad cars wasn't offensive. It wasn't designed to oppress, annoy. It was designed to achieve reasonable public policy. I also agree with Owen that the opinion written by O'Connor gave away the store with regard to judicial notions. And I will say that the one eloquent opinion, not only in that case, but really over the last decade, was written by Justice Scalia in dissent, where he said, we have something called a habeas corpus clause. The Constitution says you're allowed to suspend habeas corpus, but just as under old-fashioned constitutionalism it required Congress to go to war, under old-fashioned constitutionalism it required Congress to suspend habeas, and they hadn't done it. Now, the problem for many of us with Scalia's opinion is that his concern was confined only to U.S. citizens confined within the territory of the United States. So he had no sympathy for anybody in Guantanamo and no sympathy for any non-U.S. national confined anywhere. But over the last decade, one can become grateful for small favors. And if you want, Scalia, who is not a personal hero of mine in a way that, say, our own Barak is, Scalia is capable of writing very eloquent opinions. Most of the time, I disagree with them. But here he really was speaking in behalf of the importance of habeas and the dangers of not only allowing executive branch overreach, but of the judiciary in the name of judicial restraint or God knows what, simply engaging in an almost rubber stamp. That is the Bishop administration. You can't do everything you want. You can only do 80%. And that was viewed as a stinging rebuff of the Bush administration.
I know we have many more questions, but I've also been tasked with keeping us on schedule and getting everyone fed. So I want to thank Professor Fiss and Professor Levinson for an absolutely fascinating conversation and discussion today. Thank you all.